Γεια σας και από μένα, Νίκος, ευχαριστώ πολύ.
Hello, Nikos, thank you very much. Of course, I'm a Greek, however, allow me to make my presentation in English, because I work in English. I don't even know the terminology in Greek. I think we can all understand each other in English. And of course, at the break, if you have any questions for me, we can discuss it in Greek. But I will give my speech in English.
I would like to thank the organizers for their kind invitation to this very successful event. I mean, we heard already two excellent speakers, and from the looks of it, you're already setting up the next symposium for the bi-cluster, and I wish you all success to that as well. Now, as Nikos rightly said, so I had to say that I'm not a lawyer. So the patent attorney profession in Europe is not exercised by lawyers. We're all technically qualified people, and we pass the European qualifying examination to get the qualification. So I'm a chemist, and I'm sure we can find a common language between us. And this is the good part of it. The bad part of it is I'm going to have to speak about some legal stuff, yeah? Which I know you don't like, but it's inevitable because this is this is the game, yeah? We're talking about legal stuff. However, I try to keep it as basic as possible. I don't know if I'm going to do a good job on it, but this is the intention. So we've heard already from both speakers something about IP. The majority of that, I would say, relates about patents. Leonid even emphasized the importance of the patents in startups or even developed companies. It is a consent, I would say, that the patent system functions well in life sciences. Although there are differences, of course, between the different aspects of it. So pharmaceutical is totally different to biotech or diagnostics or even medical devices. As I said, the majority of people believe that the purpose of the patent system is fulfilled in the area of life sciences or healthcare. So what I will try to do is just to go through some very basic concepts of the patent system and to show you how it can be used either from the side of somebody who wants to protect innovations or somebody who just wants to commercialize them. Yeah? So, okay. Let's start from the most basic thing, which is what is a patent. First, I have to say that everything I'm going to say today relates to the European patent system. As I said, I'm a European patent attorney, which means I represent people before the European Patent Office. However, the vast majority of the things that you're going to hear from me apply also to patent systems in other parts of the world as well, or to national patent systems in Europe. So according to the European Patent Office, a patent confers the right to somebody to prevent third parties from exploiting an invention without authorization. And in exchange for that, the patent holder has to disclose, as we say, here's a term already, I don't know how to translate in Greek, yeah? That's to describe, basically, the invention. Yeah? So a patent is a give and take between a state and the inventor or the patent holder. So the state says, I will give you the exclusivity, and in exchange, you have to disclose your invention so the others can see it. As you probably know, patent applications are published 18 months after their filing. So everybody else can see it and can work on it. There is a research exemption throughout the world. Basically, if you work for research purposes on a patent, you don't infringe it. Yeah? And this is the purpose of the system. So already two important aspects of it are first, the fact that a patent is a national right. The term world patent used very often by many people is totally wrong. There is no world patent. There is an international application, but this is not a patent. And the second, so even the European patent, which is granted centrally by the European Patent Office and covers theoretically 40-odd countries, again, it breaks down after grant into national, as we say, a bundle of national patents. Yeah? So a patent is a national right. And the second thing is that it has a limited duration. And this is normally 20 years. In Europe, definitely 20 years from filing. Yeah? So what can be patented? The law says everything in all areas of technology that, for every invention, of course, that fulfills three criteria. The first one is that the invention has to be new, which means that It should not have been published prior to the filing of the patent application in any form, in any way, anywhere in the world. So any form of disclosure, even a discussion with somebody who is not under confidentiality obligation, is a disclosure for patent law purposes. So you can destroy the novelty of your invention just by discussing it with somebody. I know it sounds a bit crazy, but that's how it is. And if this can be proved later on, you may lose your patent. Inventive step, the second criteria. So an invention has to be inventive. Like you see that the terminology that we use, invention being inventive. Actually, invention can be non-inventive as well. As I know it's a bit stupid, but this is how we use our terminology. It's a bit strange. So for an invention to be inventive, if you take into account everything published before the filing of the application, it should not be obvious to a person who is active in that field to arrive at the claim invention. To support inventive step, basically, you need to show an unexpected result of some forms. In life sciences, this is normally a biological effect or a stability effect or a composition or something like this, but it has to be unexpected. The third criterion is the industrial applicability. In life sciences, this very rarely plays any important role. Basically, what it means is that the invention has to be such that it can be carried out in an industry. So it should not be an invention which is carried out privately by an individual. Yeah. Now, there are two major categories of patent protection. So you get protection for products and for procedures. Products can be anything: active pharmaceutical ingredients, antibodies, kits for doing analysis, pharmaceutical compositions, medical devices, anything you can think of. Procedures, there are two different categories. Let's say procedures, there's a processes, for example, a process of making a compound, a process of analyzing a sample, or things like this, and uses. In life sciences, this is very common. This is, for example, a new indication for a known active ingredient or a new dosage regime. In Europe, there is an exclusion of patentability for the methods of treatment practiced on human or animal body. This is what the law says. Some people think that this is a very wide exception that covers many things, even new indications or dosage regimes or things like this. This is not the case. The European Patent Office interprets this very narrowly. So basically, what cannot be patented are surgical methods. So a surgeon that come up with a new way of doing surgery, this cannot be patented in Europe. And sometimes some diagnostic methods, again, which are practiced on the body of the person or the animal. All the rest can be patented. So even a dosage regime, which to a scientist would appear to be the obvious thing for a method of treatment, according to the case law of the European Patent Office, it can be patented. Yeah? So this is not a method of treatment, according to them. Now, I want to come back to the first slides where I spoke about the patent being a negative right. This is very crucial. This slide and the next slide are the most important slides of my talk. You have to understand what a patent is if you want to understand how to use it. Now, what is a negative right? A market authorization for a pharmaceutical, for example, that's a positive right. So the state comes to you and says, okay, I give you the right to put it on the market. This is something positive you can do with it, yes? A patent is a negative right. The only right it gives you is to exclude others from using your invention. However, it does not give you the right to commercialize your invention. Many people think, I'm going to get a patent on this product and then commercialize it. No. You can try to commercialize it with a patent, without a patent. The patent doesn't say if you, for example, infringe other people's patents, as you're going to see in the next slide. So this is crucial for you to understand. Now, I'll try to show you this example to show what I mean in practice. So imagine, for example, company A develops a product X, they file a patent application for it, they obtain a patent. In the patent, they disclose 4 examples of X. Yeah? Now, imagine this white area of the circle here to be the scope of protection, so X. Yeah? Everything falling in here is an X, let's say. Clearly, these X1 to X4 are examples of X, so they fall within this patent. Yeah? And this belongs to company A. Now, 5 years later, company B comes in, and they develop a product which is an X, but which was not disclosed earlier as such. So X5 is a new product. It was not disclosed. Let's say that they found that it has an unexpected property as well. So as I said before, it can be inventive on the basis of this unexpected property. Yeah? So they get a patent, they found a patent 5 years later, and they get a patent for product X5. Yeah? So now the question is, what happens with commercialization here? Who can commercialize what? As I said before, Company A has the right to exclude all others from using their invention. This falls within their invention. Therefore, Company A can actually stop Company B from commercializing their product, even though Company B has a patent on it, and the patent is right. There's nothing wrong with the patent. They just cannot do it because it falls within the umbrella of the earlier patent that covers that as well. Now, Company B also has a patent on it, yeah? That means that Company A cannot exploit X5 either, because this is a patent of Company B, yeah? Now, so that means that in a scenario like this, neither A nor B can commercialize X5 without the consent of the other party. And this is a very classical scenario, this picture here, that comes up very, very often in the real world. So in the majority of cases, you may have a very nice, very valuable, very valid patent, but you may have problems with infringing somebody else's earlier patent as well. So how do you solve a situation like this? Commonly, you try to negotiate. So if you're B, you try to negotiate with A to give them a license in exchange for you to get a license. This we call cross-licensing agreement. Or, of course, if you're B, you can try to revoke A's patent, or you wait until A's patent expires, and then you can commercialize your product. Yeah? Now, somebody would say, why should B spend so much money, pay patent attorneys, pay patent offices, and stuff like this, to get a patent that cannot even commercialize? And the answer is because this is the only way of getting a strong position. If X5 doesn't file for a patent, so if this was just free, first of all, A would use it immediately if they see it in a publication or something like this. B cannot negotiate, they have nothing to negotiate, yeah? And if they put it on a paper, then on day one, A can produce it, and it's under their patent, and they can exclude everybody else from doing it, yeah? So this is not a very good idea. But even if they try to revoke A's patent, and B doesn't have its own patent, then it's open for everybody again. Not only A, but for everybody else, yeah? So the only way to get a strong position for B is to get a patent, actually. Otherwise, they're in a very bad position by doing it. Now, I hope that you understood this, because everything I'm going to say afterwards is based on this. So I'm going to try to tell you how you can use a patent strategically then. Yeah? So the obvious thing, of course, is to reduce competition. As we said before, you exclude everybody else, so you reduce your direct competition and your indirect competition as well. A patent is an asset. It can be evaluated, and it gets into balance sheets of companies. So if it's a very good one, you can increase the value of a company as well. Leonid spoke about this earlier as well. Of course, it is a marketing tool. Yeah? Everybody likes to say that this is a patented technology, and it is perceived differently. Source of income. Here you have two main categories on what kind of income we're talking about. First are the licenses. So you give the authorization to a third party to use your invention. In exchange, you get a fee. This can be a very big business. New York University, which is not the most well-known university in the world, in 2015 had more than $200 million in licensing income in life sciences, not overall, in life sciences. So this can be very, very lucrative. And of course, you have the transfers. Transfer means to sell your patent to somebody else. This also can be worthwhile doing. In many cases, you normally cover all your expenses, and you have something on the side as well. Tax reduction in Greece, and not only in Greece, in other countries as well, there are laws which say that if you sell a product which is patented, you may even pay no taxes for that specific product, but in any case, you have a reduction on your sales. Foreign market entry, through the agreements that you may conclude, either licensing or any other, with others, this may be, if you're a small or medium company, the best way to enter foreign markets through your partners. Creation of startups, of course, this applies mainly, but not only, to universities, research institutes. Very often, the most valuable asset of a startup is its patent. Improve negotiating position with competitors. As I showed before, this may be your best way to try to find an agreement with your competitor, either through a cross-licensing agreement or something similar. Collaboration opportunities. As I said, patent applications are published after 18 months, so everybody else can see. There are many, many open free databases on the internet nowadays. Everybody can see what you're doing. After this is published, your reputation gets better. It's going to be easier for you to conclude, for example, research agreements if you want to develop further your technology. Funding opportunities in many different ways, but for example, even grants from the European Union nowadays. The tenders, they mention more and more often the IP issue and what are you going to do with this, or if you have a patent already and you want to develop something further, this plays a major role as well. Overall, all of the above and other things improve greatly the reputation of an organization, be it a company, university, whatever it is. It is always a big increase in the reputation if you use the patent system properly. Now, how do you implement that? Basically, what you try to do is to create what we call patent portfolio. So you don't stay with one patent, you try to build a portfolio to get as many patents as possible for a given technology. Why? Because you get additional value from all of these things, and you lower your risks, of course, yeah? So, for example, you can try different aspects of a technology. If your initial technology is a product, you may try later to cover processes or uses of that same product. Or you can further develop the product itself, yeah, and improve it, and then get additional patents on the improvements of your products. The important thing to understand is that there is no one-size-suits-all situation in this. Every technology is different, every project is different, there is a lot of flexibility, you can come up with different things, and you should be coming up with different things for different technologies. I would like to mention two things here which are very important for patenting, and especially here in Greece, they're problematic, I would say. First has to do with the timing of publications. This mainly applies to universities and research institutes, but sometimes to companies as well. As I said before, a patent to be protected, for a patent to be obtained, the invention has to be new. So if you sell it to the paper and it's published, or if you go to the conference and show it, and you want to file a patent afterwards, forget it. It's not new, yeah? But it's not only that you need to at least wait until you file your application. This is the direct problem, let's say. There is an indirect problem with the publications as well. Normally, researchers work in a specific narrow area, and they tend to publish a lot in that area. So at some point, they realize that, oh, yeah, okay, some part of it, maybe we should try to get a patent on it. Now, if you have published everything around it, and just at the end, you make the thing in the center, which is new because you haven't done it before, but all your previous publications point to that. You may not be inventive because of your own publications of the last 2, 3, or 5 years. I know for patent examiners from the European Patent Office, when they get applications from research institutions, the first thing they do, they try keyword for the inventor. So they put the name of the inventor and they get the best prior art from that. That's how they approach it, because it is true. So if you want to be involved in the patent business, if you want to try to protect your innovations, you should adapt your publication strategy accordingly. The second thing is for the rights of the applicant. So a patent is filed in the name of the applicant, that's normally the company, the university, but the right initially becomes to the inventor, and the inventor is always a natural person, the one who developed it. Now, for a patent to be validly filed, the rights of the inventor has to be transferred to the applicant before the filing of the patent application. This is a matter of national law. The Greek law provides how this is done. This is not the issue to be mentioned here. The thing is, if you don't pay attention to this, if you make a mistake there, in the vast majority of cases, you cannot do anything with this. And you can even lose your patent. For example, if you try to sell your company, but your patent, the first thing the other party is going to do is what we call the due diligence. And they will get into the issue of rights. If they see holes there, you're not going to sell it. It may be the best invention in the world. Trust me, you're not going to sell it. So the issue of rights is extremely important. In Greece, it's very problematic, especially in universities and research institutions. This is, of course, a topic for another conference. I'm not going to get into it. But you have to sort it out. You have to try to find ways to sort it out, because this is a great problem. Now, finally, irrespective of the fact if I manage to convince you to file for patent protection, the thing is what you should do when you exploit it, yeah? And of course, the thing is you have to monitor your competitors' activity, because even if you don't want to file for an application, if you're in the business of innovation, all the others file patent applications. So you're going to have problems with infringement, yeah? So you have to monitor what the competitors do. This may be a very good source of technical information, for example. You may see what the competition does, and you may even get, first of all, you should not duplicate things. So if you see something that you're doing and then already there's a patent application published on it, you can immediately stop it. Or you may get some ideas how to direct your future research in a different way, yeah? And to be able to develop inventions that can protect. And of course, through seeing what the competitors do, you can make what we call freedom to operate analysis, which means not to fall within the patents of the competitor. So you analyze the situation, you see which patents are there by the others, to see if you're going to have a problem when you financially exploit your innovation. Of course, you try to avoid third parties' rights. Sometimes this is not possible. So what do? Sometimes you're going to not go to litigate. You're going to try to revoke, for example, the other party's patent. In Europe, as it currently stands, and I emphasize this, as it currently stands, if you go to a court, this is a national court, if you want to revoke a patent, who takes a national decision. So if you're going to revoke a patent in Greece, Germany, UK, you have to go to all three different courts in the three countries to obtain a decision on that. This, of course, increases the cost and increases the risks, because the courts do not agree with each other all the time, even in Europe. A very good option, which is very rarely used from companies from Greece, is the opposition before the European Patent Office. So after the grant of a patent, and for 9 months after that, and this is the important bit, for 9 months after the grant of a patent, anybody can file an opposition at the European Patent Office saying you should not have granted this, please revoke it. There is another centralized procedure there at the office. It very often leads to revocation of patents. So it's one procedure, it's much lower cost than going nationally to courts and things like this, and you can take out with one decision a patent. And then finally, another even more cost-effective option is even the third-party observations at the European Patent Office. So at that stage where a patent application is still pending, you can send some arguments to the European Patent Office and tell them, you know what, you should not be granting this for this and this reason. You can send supporting documents as well. The examiners very often change their minds on the basis of this, because you may have a better document that they have found, or they may have not seen well some parts of the application. This is very effective as well. You're not part of the procedure there, so there is no new procedure starting. You just file this and wait. But it is very effective and cost-effective, of course, as well. So although I could continue for another couple of hours, I think, speaking about patents, I'm going to have to stop somewhere here. So I hope I've given you a very rough idea of what the whole issue is about. The important thing is to understand that a patent is a negative right. I repeat it once again. I think it is inevitable that one way or another you're going to be involved with the system if you're involved in innovation. In my view, it's imperative for any organization, be it a company, university, or anything else, to get to know the system as well as possible and to try to use it to the best of its effect, because it really can be the benefits of the system very, very significant for everybody. So thank you very much for your attention, and I'm at your disposal for questions.
On what grounds are revocations generally done on? How do you revoke a patent?
Okay. So the revocation and the opposition of the European Patent Office involves all but one the same ground. So basically, you can say the patent is not novel, or is not inventive, or is not industrially applicable. So the three criteria I showed at the beginning, yeah? This is one category of grounds, let's say, for that. You can say that a patent is not sufficiently disclosed. If you remember my first slide, where I say in exchange, the inventor has to disclose his invention. So if you write it in a way that is extremely vague, and the person skilled in the art, as we say, so somebody who is active in the field cannot repeat it, this is a ground for revocation. Many people don't know that either, and say, leave this out, leave this out. Well, it's very dangerous to leave things out, irrespective of what many people think about patents, because it's a ground for revocation, yeah? And plus, if you extend the content of the initial application in Europe, all over the world, but in Europe, they're more strict on this. You are restricted by your initial content. So you cannot add things later on, technical things. I mean, to say, yeah, now, but if I add this technical feature as well, I can prove you that I have an advantage. This is a no-go. If you do that, you extend your initial content, and this is also a ground for revocation. All these things can be done nationally as well, if you go to the court to revoke on this basis. Additionally, in national courts, you can say, and I come to the issue of rights here, if the applicant was not the one at the time of the filing who should file the application on his name, this is a ground for revocation as well. So if the real owner of the rights of that time of the patent application comes in and says, I should be the real owner, this is a ground for revoking a patent. Yeah. So I hope I've given you part of an answer. Yeah.
Great, thanks. Great talk. As companies and people are getting more clever, let's say, in this patent game, I'm sure you're experiencing this more and more. People are challenging the basics, so the breadth of claims, and in the end of the day, it boils down often to definitions and the interpretation of definitions, as you well know. Now, in many patents in the life sciences, but in general as well, it's the practice from the part of the patent attorney for their clients to try and make claims as broad as possible, and then if you're trying, if you're on the other side, you're trying to minimize that breadth. So is this the management of this tension between the breadth and the narrowness? How is it developing in terms of what kinds of instructions you're getting from the European Patent Office in this case of how to deal with this tension? So is it getting better, or so you said that in Europe we're more strict than in the US, and it's true, but exactly how is it happening?
Yes, well, it's always one of the most difficult aspects of our job, because this is normally, as you say, Andreas, this is normally what we do. Yeah, so the client comes in with something that he believes is the invention, and then we try to widen it as much as possible. It is a very fine balance. You should not overextend in things, because then you may have issues of disclosures. As I told Leonid before, if you try to say that I can do everything with my invention, and at the point of the filing, it is not known how you can do all these things, this is not a good strategy, because you may lose your very wide claim. And if you had just made it a bit narrower, you could have achieved it maybe. Yeah? So it's very difficult to foresee how the office will react to this. In any case, in Europe, even this criterion is looked at very carefully by the European Patent Office and very strictly. For example, in the patents, in the new, not so much new indications sometimes as well, but especially the new dosage regimes, which are based on clinical trials. Yeah? There is a tendency to give a patent relatively easily, even if you don't have the results of the clinical trials, but more and more patents get revoked because of that. So companies just put in the patent application the design of the trial, but not the results. Then other people attack that by saying it's not sufficiently disclosed because you haven't actually done it. And at the European Patent Office, you get more and more revocation on this basis. So this is something which has to be looked at extremely carefully. And in any case, what you do when you draft a patent is you create levels. So what the difference in the European drafting and the American drafting? In the USA, they have a very wide claim and then a single compound. Yeah? So one chemical formula encompassing 10 million compounds and nothing in between, just one compound at the end. When this comes to Europe, you're normally left with this one compound. Here in Europe, we draft it differently. We try to put levels there. So if you lose the 10 million compounds, you make it a bit stricter. You go down to 10,000 compounds and then down to 1,000, to 50, to 2, yeah? And this is a way, for example, of getting away from problems like this. But it is extremely important to look at it.